measure. It appears to be equal in law, but it is discriminatory. In fact, discriminatory in relation to who? BASCA, this French company, this fictitious French company. Once you get to this point, you need to change your focus to the government of the member state, the author of the measure. The question is, in the litigation process, how are they able to justify the introduction of this measure? How are they going to be able to justify the introduction of the Wine Law 2023, noting that it amounts to an MEQR, which is in contravention to Article 34 of the TFPU? Well, they have available to them certain derogations. The derogations, we know, are divided into two. There are derogations attached to Article 36 of the TFEU, and there are also derogations arising out of the case of Cassis de Dijon, namely mandatory requirements. One is statutory, the other emanates from case law. One is a fixed closed list, the other is a non-exhaustive list. The availability of these derogations depends on whether the measure in question is distinctly applicable or indistinctly applicable. If the measure in question is distinctly applicable, then the government of the member state is limited to the statutory derogations set out at Article 36 of the TFEU. They cannot use the derogations listed under the mandatory requirements in that regard. However, if the measure in question is an indistinctly applicable measure, then both sets of derogations become available to the government of the member state, i.e. Article 36 of the TFEU, as well as the mandatory requirements set out in Cassis de Dijon. So, we need to think about which derogations